CCJ Appeal BBCR number 2 of 2021 between the Commissioner of Police and Stephen Alleyne. The court's full bench sits to deliver this judgment. They are Mr. Justice Saunders, President and the Presiding Judge.
Good afternoon, everyone.
Mr. Justice Witt.
Good afternoon, everyone.
Mr. Justice Anderson.
Good afternoon, Counsel.
Madam Justice Rochnott-Lee.
Good afternoon, everyone.
Mr. Justice Barrow.
Good afternoon.
Mr. Justice Burgess.
Good afternoon, everyone.
And Mr. Justice Jamadar.
Good afternoon, everyone.
May we have the appearances, please? Thank you.
Good afternoon, Your Honours. If it pleases this Honourable Court, Crystal Delaney, along with Oliver Thomas, appearing on behalf of the appellant.
Good afternoon, Milas and Milady. Asa Holder, appearing in association with Ms. Alleyne, Ms. Mariah Asa, Mr. Anthony Granger, and Ms. Nakasi Blair, on behalf of the respondent who is present.
Yes, thank you, Counsel. The judgment, the lead judgment in this matter is delivered by Mr. Justice Barrow. There was a dissent, but I would have Mr. Justice Barrow read a summary of the judgment.
Thank you, President. This, of course, is a summary. It should not be used in place of the full text of the judgment for any official purposes. Stephen Alleyne was charged with the offense of rape contrary to the Sexual Offences Act, the Act. Before the start of the evidence in his trial, he was discharged by the magistrate after hearing submissions that the charge alleged that he had sexual intercourse with another man without his consent. The magistrate decided that the crime of rape in section 3(1) did not extend to anal intercourse between men. On appeal by the Commissioner of Police, the majority in the Court of Appeal agreed with the magistrate's decision. The Commissioner of Police appealed to this court. The court, in a judgment authored by Justice Barrow, found that on a correct interpretation of section 3(1) of the Act, a man can be charged for the rape of another man. The Act uses gender-neutral language and extends the definition of rape to include anal penetration. The court found that considering the literal meaning of the words used in the Act, their context, and comparable legislation, any person, male or female, can be the offender or victim of rape. The retention in the legislation of the offense of buggery did not prevent males from being charged with rape, as the Interpretation Act, Section 22, allows offenders to be charged with either offense once they are not punished twice for the same act. The court noted that it was aware that the issues of the constitutionality of the offense of buggery has been adjudicated in several courts, including within the Caribbean. However, the issue did not arise for decision, and in the circumstances, it was the duty of the court to exercise proper judicial restraint and refrain from deciding an issue that was not argued before it. In a separate judgment, Justice Jamadar entirely supported the opinion of Justice Barrow and agreed that the Act permits a man to be charged for rape of another man. Justice Jamadar found when judges are interpreting legislation, they must also respect the fundamental rights in the Constitution and consider a state's international treaty commitments. A gender-neutral interpretation of the Act respects the right to protection of the law regardless of sex and the prohibition against discriminatory laws under the Constitution. It also respects Barbados's international law commitments to ensure equality before the law, regardless of gender, and the enjoyment of fundamental rights and freedoms without restrictions based on sex. In a dissenting judgment, Justice Burgess found that the act does not create an offense of rape of a male by another male, and he would have dismissed the appeal. He considered that under the common law, only a man could commit rape and only against a woman. He found that Section 3 of the Act does not purport to do anything as revolutionary as changing the common law to create an offense of rape by a male of another male. For Parliament to do so, it would have had to express that intention in clear and unambiguous language. He considered the natural and ordinary meaning and legal meaning of the words used in Section 3, as well as their context in the Act as a whole, and the rules of natural justice. Justice Burgess found that the words sexual intercourse used in creating the statutory offense means penile vaginal penetration. He found that Section 3(6) of the Act modifies the common law by providing that not only a man can commit the actus reus of rape, but any of the parties to sexual intercourse, a male or a female, can do so. The appeal was therefore allowed and the case remitted to the Magistrate's Court for it to proceed with the preliminary inquiry. Thank you, President.
Yes, thank you very much. Is there any comment, question, concern, issue by counsel?
No, Your Honors.
Okay. In that case,
No, Milady.
yes, thank you, Mr. Holder. In that case, I wish to thank you for your attention, and I invite the Deputy Registrar to close the proceedings.
Thank you, President Saunders. Thank you, Mr. Justice Witt. Thank you, Mr. Justice Anderson. Thank you, Madam Justice Rajnath Lee. Thank you, Mr. Justice Barrow. Thank you, Mr. Justice Burgess. And thank you, Mr. Justice Jamada. Thank you to counsel, and thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.
Thank you.